Gregory.
No, I mean, I think I think there's a reason why the FCC hasn't gone back to Congress. It must feel it won't get what it would ask for, and whether that's because of other legislative priorities or because there's not a majority that wants to give the FCC more authority in this area, which would likely lead to more regulation. I don't know. I mean, the one thing that I would say is I think that there is a benefit to having certainty here. I mean, when there's not certainty, what you have is the chill of the threat of enforcement against the companies that are providing these internet access services. So the one thing that seems to me very problematic about where we are now is we're having this debate today where, you know, virtually all of us concede or admit or acknowledge that there is very little, if anything, to the FCC's exercise of ancillary jurisdiction under Title I, that at a minimum it's tenuous. There's debate about Title II, but yet the FCC hasn't publicly put the focus on Title II, so we don't know where that is. And then, you know, Helgi raises the interesting third option of just kind of the piecemeal approach. But the one thing that seems to me that's missing, that everyone suffers from, is a lack of certainty.
Under Title I, the Commission in its brief in the Comcast case argues that Title I grants it standalone authority. And cites Southwestern Cable as Title I imposes responsibilities on the Commission that the agency is required to fulfill, cites to a CCIA case, rural telephone, GTE, and distinguishes the cases that you relied on in your brief. You want to talk a little bit about the role of Title I as a standalone grant of authority that the Commission
Well, I mean, Title I, I think, is for those who aren't avid readers of the Communications Act, Title I says...
First of all, congratulations.
Yeah.
I have a copy if anybody wants to peruse it.
It just says that we hereby create the Federal Communications Commission for the purpose of regulating, you know, the nation's radio waves and for the fast, efficient, and wonderful distribution of information in America, your Congress. That's the provision we're talking about here. And the FCC has relied on that as the substantive source of authority pursuant to which it could adopt ancillary authority rules. So without wanting to waste everybody's time, I mean, that argument is even weaker than Section 230 and 706, which my intellectually honest friend to my right, or should I say left, Gigi has already acknowledged. So that's even weaker than 230 and 706. But one thing I wanted to briefly touch on, because I thought it might be of interest to this group and is important, is what the regulatory agenda of some of those who are promoting Title II reclassification really is. Now, I think there are folks who are seeking legal certainty for their legislative and regulatory goals, and that's one thing. But a man named Robert McChesney, who founded the public interest group Free Press, who brought the enforcement complaint against Comcast, has said in an interview with a internet publication called The Socialist Project that, quote, what we want to have in the U.S. and in every society is an internet that is not private property but a public utility. Our struggle is to make the internet into a public utility. Well, internet broadband networks, of course, are currently private property. And for some, the Title II reclassification debate is really an agenda to transform that private property into public property. That's why takings issues are now popping up in the regulatory proceeding on the NPRM. So I don't want to be hysterical about this, but those who are pushing Title II have openly said that their goal is to take this private property and turn it into public property, because only then can it be safe for all Americans to use.
Okay, I got to defend my colleagues at Free Press. We don't always agree on everything, but I mean, this is just kind of red baiting. I mean, Robert McChesney doesn't. I mean, I know, but he doesn't make the policy rules for Free Press. I mean, Reed Hunt is on my board. Do you think that everything that Reed Hunt ever said you could ascribe to public knowledge? That would be a pretty scary thought. And I love Reed Hunt. Let me get on the private property meme, because telephone companies and cable companies dig up rights of way. They use, you know, public pole attachments. They use spectrum licensed by the government that belongs to the public. There's no private property here. Okay, this is not. I mean, if you want to make a takings argument, be my guest. I think you
don't think Comcast owns its pipe.
They own this pipe, but they don't. You know what? If they didn't have the rights of way, if they didn't get rights of way permission to use a rights-of-way from the localities, they'd have a pipe. That's what they would have. They would not have an internet service. They would not have a cable service. Your client and AT&T and Verizon and others cannot survive without permission from, from public entities, from taxpayer-supported entities. And, just to say this is private property like a car or a house, it's not supported by the law. It's not supported by reality because, yes, it's their coaxial cable, but they don't have a business unless some government gives them permission. Same thing with the airwaves. The FCC licenses the airwaves. There would be no wireless industry, and there almost was no wireless industry, without the FCC say-so. That's not private property. That's a license.
Preview of debates to come.
Exactly. A lot of it was made in Greg's paper, and we talked about it a little bit here, about ancillary authority can't be exercised in a way that's otherwise inconsistent with the statute. And most commonly, the non-discrimination requirement is invoked among the 6 principles as being inconsistent with the rest of the statutory scheme, particularly as a pure non-discrimination mandate, which is the current draft, because it is a heightened standard even from Title II. What about the other 5 principles? Are those similarly inconsistent with the statute? Is there some subset of net neutralities, the proposed 6 net neutrality rules, that could pass the otherwise inconsistent with the statute test?
I mean, I haven't gone through and checked off each one. I mean, the one thing that I would say is I view it, the inconsistency with the statute is sort of the cherry on the top, or the nail in the coffin, depending on where you are in the policy debate. There are other fundamental problems with ancillary jurisdiction, the exercise of ancillary jurisdiction, before you even get there.
I mean, again, a lot of it depends on whether you consider this regulating the internet or regulating internet access. Okay, if you consider it regulating internet, there are certainly things in the statute that would appear to be inconsistent. But I think, you asked, Brian, one of your questions is what's the single biggest misconception of your opponents? And while I had a list of about 6 of them, I think the biggest one is net neutrality would regulate the internet. Net neutrality is very narrow. Okay, it governs the relationship between the customer and the ISP, and the bottleneck control that the ISP has and market power that it has in a world of high switching costs, information asymmetry, other barriers to entry. So I think it's really, really important for people to recognize, and this is where it drives me crazy when people say, well, what about what Google is doing in Akamai and, this and that, and Bob McChesney, about what, let's regulate what they're doing. And I find that incredibly ironic that the same people that don't like net neutrality regulation would then want to apply regulation to all the application, content, and services that make up the internet. Net neutrality is about networks. It's not about Google. It's not about Akamai.
Helgi,
sorry if I just took out like 3 of your questions.
Yeah, that was wow. Helgi, is there
entertaining?
Is there a right way that you could exercise ancillary authority to get to the other 5 principles, putting aside discrimination?
If I were the general counsel of the FCC, which I am not, I could possibly take a crack at finding some substantive provision. I'd have to flip through the whole act. I'd have to build a record, and I'd have to do that boring, drudgery, administrative law work that, frankly is what's required, but is not a ton of fun. So I can't answer your question one way or the other, but it seems to me it's certainly theoretically possible.